Our first case is State of Ohio, ex-rel Attorney General David Yost versus Orrville Tobacco and Vape Shop, LLC. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
2 minutes, Your Honor.
2 minutes, very good. I will be keeping time up here. We'll see if this hum continues, but if it does, it does. I'll try to let you know about a minute left on your initial time.
Thank you, Your Honor.
In your rebuttal with 2 minutes, I won't give you any warning. And I'll give you warning about a minute left as well, counsel. So pardon my interruption, you have one at a time. The arguments are being recorded, so when you come up to the podium, please stay behind the podium so we can see and hear you. And also please introduce yourself and your client when you come to the podium. I don't think in this case it matters, but if you refer to any victim or minor or anyone, please use initials for anyone like that, but I don't think it matters here in any way, shape, or form. With that, the parties have read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. I'm Assistant Attorney General Bruce Smith. In this situation, I represent the appellant in the state of Ohio. The state of Ohio filed a complaint for a violation of Consumer Protection Sales or Consumer Sales Practices Act for the deceptive sale of unregulated and illegal vaping products. In doing so, we are exercising the state's historical police powers, and these are not to be assumed to be superseded by federal law unless it's a clear manifest purpose of the federal regulation. The CSPA prohibits suppliers from committing either unfair or deceptive consumer sales practices or unconscionable acts or practice as cataloged in Revised Code 1345.02 and 03. Appellee, in our complaint, we allege that they violation of the CSPA as follows. They failed to clearly and conspicuously disclose the illegal and unregulated vapes he sold were not legal or regulated. They took advantage of the consumer's lack of knowledge to protect their own interests when they were purchasing these vaping products, and they failed to clearly and conspicuously disclose material exclusions about these vaping products. Defendant filed a motion to dismiss in accordance with Civil Rule 12b-6, and the standard is to test the sufficiency of the complaint. The court must accept the allegations as true. The court must find beyond a doubt that plaintiff appellant can prove no set of facts in support of the claim which entitle us to relief. And again, as I indicated, the court below granted this motion to dismiss. The review is de novo, and our position is that granting the motion to dismiss is apparent. I will address the reasoning set forth by the lower court first, but as I said, this is a de novo review, so I will also touch upon the arguments that the court explicitly rejected.
Before we went too far, let me ask you a question about the motion to dismiss and your claim there were some attachment to that.
Correct.
Looking at the electronic document, at least, from the trial court here, I can't find any attachment to that motion to dismiss.
And counsel for appellee was correct. It wasn't attached in this circumstance, and he indicated that I was conflating other appeals as we're going around the state.
Okay.
I don't think that changes anything. He referenced those documents, so rather than attached, referenced this evidence. So I'm treating it as the same, and I believe it is the same in accordance with law.
Well, I don't have to try to figure out where these things got to. Is my concern for the moment.
Please stop looking. Okay, thank you, Your Honor.
Thank you.
I argue this is extrinsic evidence, and the 12b-6 is not allowed to look at extrinsic evidence. The proper thing to do is change this into a motion for summary judgment so that I would have the opportunity to present my own evidence with regard to that extrinsic evidence. Now, the reason we consider it extrinsic evidence is the fact that the documents were so far off the opinions of the FDA in this. The documents indicated, the author of the documents indicated that the FDA did not enforce a law against unauthorized vaping products as a policy matter for the purpose of striking this balance between the serious risks that e-cigarettes pose and their potential benefit to help tobacco smokers. This is in direct contrast with the FDA's own leadership, who testified before a Senate hearing. This is Dr. King, the director of the Center of Tobacco Products at the FDA. These folks' bosses testified under oath at the U.S. Senate judiciary that it is not because of a choice that they're making. It is because of a lack of funding. It is because they're behind the ball on this. And it is just because they're overwhelmed with the amount of applications. Now, when they got this wrong, you've got to look at the rest of it and say, is this evidence of the FDA's opinion, or is this indeed the FDA's opinion? When you look at something that's so conflated with their own leadership, I would argue that it's just evidence of the FDA opinion. And you've got to look at, and I should have had the opportunity to present that evidence that indeed these things aren't the FDA's opinion because of the testimony before the Senate.
Well, counsel, the exception is that a court may take notice of a document or record. Are these documents or records?
They are documents or records, but they do not represent, my argument would be, Your Honor, that they do not represent the opinion of the FDA. If the court were to treat that just as or documents that are the opinion of an agency, I would also say that they don't pass the Loper and Skidmore test. Loper v. Raimondo held that interpretations of laws is the province of this court, and they can choose, or you can choose, to give deference to agency interpretations of law if you choose to treat this as an agency interpretation of law. Now, Skidmore v. Swift, a case way back from 1994, gave us the analysis that the court should go through in terms of deciding what weight these sort of decisions from agencies should be given. They should look at the thoroughness evident in their reasoning, the validity of their reasoning, its consistency with earlier pronouncements. Now, as I've already mentioned.
Counsel, is there any real factual dispute in this case? It seems to me that, as I read this, the parties agree that federal law requires this label to be placed on these products.
No.
When they're sold. So you don't agree with that?
Absolutely not.
Why do you not agree with that?
Because if you look at the statute, what they're arguing here, first of all, there is no judicial precedent for this. Again, under Loper, these agency documents are to be, they can have deference if the court chooses, but they're not worthy of deference. The appellee puts us forth with the idea that e-cigarettes that are illegal to introduce in the U.S. market are required to have the label that they are allowed to be sold in the U.S. market.
Well, I understand their position to be any of these products being sold in the U.S. market, not just ones that are illegal, but any market, any product being sold has to have this label, legal to be sold, or allowed to be sold in the U.S.
Well, what we have is a circuitous argument because these aren't legal to be sold in the U.S. They're not supposed to be.
Well, I understand that's the argument, and that's not the state's job to enforce that. That's the federal government's job to enforce. Is that fair?
It is the state's job to enforce that they're not sold in Ohio in a way that is deceptive.
And your view of that is the Consumer Sales Practice Act, but there's no other requirement under Ohio law that affects the ability to sell these products.
Correct.
Okay. Is there this label is placed on there? That's pursuant to statute, I take it.
Well, Your Honor, I would argue that that label needs to be placed on products that are correctly introduced into the marketplace. If you look at the FDCA, unauthorized e-cigarettes, which is what we have here, is adulterated as a matter of law. That's 21 U.S.C. 387b6. The FDCA prohibits the introduction or delivery of introduction to interstate commerce any tobacco product that's adulterated.
And whose job is it to enforce that?
It's the FDA.
Okay. Are they enforcing this?
They are at times.
Okay.
They are at times, and right now as we speak, they're joining in a task force, and after that Senate hearing, it seems to me that they have stepped up their enforcement as they've been exposed, as one senator said, falling down on the job.
So you would say the Consumer Sales Practice Act safe harbor does not apply because this is not required by federal law?
Correct.
And why is that?
Absolutely. So, as I was saying, the FDCA requires that tobacco cigarettes for introduction or delivery interstate shall bear this statement. But again, these are not required. These are not allowed to be involved. So how can I label for things that are allowed to be? And the label makes sense then, for sale only allowed in the United States. Obviously the intention of the drafters of the FDAC were intending for this to be on e-cigarettes that are allowed to be entered. We're getting far afield. And then the only evidence, and you argue that it was opinion with regard to this, is a letter from the FDIC which does not pass the Loper and Skidmore analysis. This analysis, first of all, the court doesn't have to take it as law. No other court has. You're being invited to, as a court of appeals, turn this logic into the stare decisis system. And I would argue that this is the exact reason that we had the decision that was made by the Supreme Court. This is Exhibit A as to a situation where you should take the opinion of the FDA, look at it, and decide whether it passes muster. And I don't think it could be argued that it does.
It certainly, we have the right to look at it. It's persuasive authority. We can decide if it does or doesn't make sense and make our own determination. Doesn't mean we don't follow it. It just means we have to decide if it is an appropriate decision to follow.
Yes, Your Honor, and I just argue that it is indeed not an appropriate decision to follow because the reasoning is weak. The rest of that document doesn't align with the head of the FDA and their purposes. And so there's a lot of things if you go through the Skidmore analysis, which the Supreme Court says is the analysis here, it doesn't pass muster, is my argument.
Did the complaint have a count for declaratory judgment? Because we have a dismissal.
Right.
And usually if there's a declaratory judgment action, we can't just 12B6.
Your Honor, there is. It does involve a declaratory judgment.
Okay. And when I read the order, I didn't see a declaration. It was a dismissal that I'm used to seeing under 12B6.
Okay. Thank you, Your Honor. That's a very good point. If I can go then through some of the reasoning the court used with regard to the Safe Harbor Act, it's not applicable. The Safe Harbor Act says the CSPA does not apply to an act or practice required under federal law. First, the deceptive sale of a legal vaping product is not required or permitted under federal law. In fact, the sale of vaping products is in violation of the federal law. Court held that the sale was only problematic because of this required label. And Your Honor, I would again indicate that this label in our position is not required because the court is not required to follow the FDA document referenced by the appellee. The sale only in the United States must be affixed to the product. They're not allowed to be sold in the United States. That's a requirement.
About a minute left, counsel.
Okay. I want to look into implied preemption then. The lower court held that the state of Ohio is impliedly preempted from protecting Ohio consumers. With regard to this implied preemption, the court must consider whether the state law stands as an obstacle to the accomplishment of the full purposes and objectives. First of all, we are aligned with the objectives of the FDA. Secondly, if the FDA decided not to act, we deal with the deceptive sale of these, and they can flood the market if they choose to with these unregulated vapes, and we can still manage the deceptive sale. So there is not a direct conflict at all. They rely on two cases, Buckman and Loretto. These involve private parties. These are not on point. Buckman explicitly does not involve a field traditionally occupied by the states. They deal with medical, and so there's no presumption that there is authority for the state to act as there is here when we're involved with consumer protection.
Counsel, your time is up, initial time.
Thank you.
You're welcome.
Morning, Your Honor. May you please support. My name is James Frazier, and I represent the appellee, Orrville Tobacco and Vape Shop, LLC. And I'll start with the statute that says all tobacco products have to have the word sale only allowed in the United States. Your Honor is correct. We did not attach the ITC document to that. But regardless, it's a question of law, and the court below didn't rely on it anyway, so it doesn't seem like it would.
Well, my question again was this, Do I have to try to find this in the record somewhere where I can't find it? So we all agree it's not in the record, so we need to worry.
Here's what I would say, though, but it is a legal question. So the legal question is, does the statute not apply to a tobacco product that is unauthorized by the Food and Drug Administration? And I would say that when you look at the FDCA as a whole, well, first of all, there's no limiting language in that particular provision of the statute anyway. It just says any tobacco product. Any means any. If you look at 21 U.S.C. section 331, I can't give you the pin, it's a long section, but that is the Food and Drug, the FDCA list of prohibited acts. These are acts that are actually, you know, crime, or the FDA can bring civil actions against you. It actually says any tobacco product cannot be labeled as approved by the FDA, because FDA and Congress doesn't want people looking at products and going, oh, this must be okay. The FDA said it's okay. So you've got that. And then if you look at the statute which defines misbranding of tobacco products, which includes not having the language of sale only allowed in the United States, that statute says a tobacco product is misbranded if it does not have that language. It refers to the statute that says sale only allowed in the United States. Now, if Congress had wanted to make it a violation of the Food, Drug, and Cosmetic Act to sell a tobacco product with the words sale only allowed in the United States, if the product was not authorized, Congress would have put that in the statute. It would have been pretty easy to do. So I
take the state's argument to be just commonsensical that for you to have that label on there, it must be approved to be sold in the United States, and this isn't sold here, so therefore it's a violation.
Sure. And
Of the statute.
my response to that, Your Honor, is, as I mentioned before, the Food, Drug, and Cosmetic Act is a criminal statute. And, you know, you certainly would have to read that statute strictly. You know, somebody can be put in jail for a year or fined $1,000 for selling a misbranded tobacco product.
What's the violation for selling an unapproved tobacco product?
There are no approved tobacco products.
Well, whatever, there's just
there
standard.
are authorized tobacco products.
Thank you for the clarification.
Yeah. Just real quick, and I worked at the FDA for 5 years, so let me explain this to you real quick. So the Food, Drug, and Cosmetic Act has a section 331 that the front end of that section basically says it's a violation to sell misbranded and adulterated products in interstate commerce, food, tobacco, whatever. And then for a violation of that, regardless of the product, the first time violation is a misdemeanor, $1,000 fine.
Do you agree that these products are adulterated products?
Yes, any product that does, any electronic cigarette in the United States that has not been authorized by the Food and Drug Administration is an adulterated product. And I would tell you that if you walk down the street within 5 minutes, you'd be able to probably walk into a shop that sells a product that is sold by R.J. Reynolds, the biggest tobacco company in the world. Some of their Views electronic cigarettes have not been authorized by the FDA. And the FDA, I would disagree.
So they're adulterated, is what you're saying?
Absolutely. And
does that make it okay, or how's that help?
The argument isn't that it's okay. The argument is that with 337A in the Food, Drug, and Cosmetic Act, Congress said that only the United States can enforce this act. And this happens quite often. You see in product liability cases and other types of cases where the plaintiffs will allege, well, this product didn't meet the FDA requirements. The courts will say, well, people other than the United States can't enforce this act. What states can do if they want to, and some have, and the state cites these in the cases, can enact statutes that just enact in total bans on classifications of products. So, for example, the state of California has banned all flavored tobacco products. So, menthol cigarettes, just regular old menthol cigarettes, you can't buy them. that's fine. And they've banned all flavored electronic cigarettes. The state of New York has done the same thing with electronic cigarettes. So states are free to do that. However, what the law says is when and those statutes don't rely on the existence of the Food, Drug, and Cosmetic Act. If Congress repealed the Food, Drug, and Cosmetic Act tomorrow, or the tobacco provisions, those states' laws would just go on like they are right now. But the state would have to agree that if Congress repealed the Food, Drug, and Cosmetic Act's tobacco provisions tomorrow, they would have a tough time bringing these cases. Tobacco manufacturers would stop putting that language on their products because it would no longer be required. And I don't know what the state would say at that point.
Well, then the state would be free to pass their own law regarding.
That's absolutely
tobacco
true. That's absolutely true. And we're not saying the state doesn't have the authority to pass a law that specifically bans categories of cigarettes. And
You would say they lack the authority to ban sale of all unauthorized cigarettes.
all cigarettes not authorized.
Because that's based upon the FDCA's requirements rather
That's
than
absolutely
something.
And do they have the authority to have a law that bans deceptive practices
They
in
do.
sales?
They do. But our argument would be is
Regardless
that if their evidence of deception relies on the existence of the Food, Drug, and Cosmetic Act provisions, then you have run afoul of 337A. And one point,
The Safe Harbor Act.
the 337A is the FDCA provision that says no private or no enforcement by anyone other than the United States of the Food, Drug, and Cosmetic Act.
And also the Safe Harbor Act based upon the
Correct.
Intoxicating
Yes.
Sale Practice Act as well.
So if there was some other harmful substance, some illicit, I don't really know how these things work together, but let's just say you could have fentanyl in your adulterated product. And you put that thing on there that you're suggesting is required because there's tobacco in it,
Mhm.
right? You could just sell that?
I'm sorry, so if
the vaping-
if the federal statute required the product
Well,
to
it's
say
a tobacco.
Okay.
There's tobacco in it too.
There's nicotine in it, yes.
Yes. What I'm saying to you is, like, if it's laced with something
Okay,
even more, that is illicit,
yes.
because the federal law, if I understand your argument, requires that you put that on any tobacco product. Could you just,
Put what on the tobacco products?
the label,
illicit?
yes.
The illicit?
No.
No, the fentanyl or?
No,
Just-
the fact that it is sold, is only to be sold in the United States.
Oh, I see. I think at that point, Your Honor, the state would not be prohibited from bringing an action just for selling a product that is poisonous in some way. And frankly, that's how in product liability cases, plaintiffs get around that 337. They're saying, again, going back to, let's say the FDA removed all these requirements, the product would still, we could still be in violation. The problem is when states say it is because of a violation of the Food, Drug, and Cosmetic
Okay.
Act that we're able to bring this.
I understand your argument.
The last point I want to make real quickly is about the preservation clause of the Food, Drug, and Cosmetic Act with respect to tobacco. I think if you look at the context in which that was passed, it's really informative of what Congress was trying to get at. If you look in, it's 21 U.S.C. I believe it's 371. I'm sorry. I apologize. 21 U.S.C. It's 387 lowercase a dash 1. And the title of that section in the Food, Drug, and Cosmetic Act is called Final Rule. And that provision of the Food, Drug, and Cosmetic Act required the FDA to readopt regulations that the FDA had adopted in 1996, which made it a violation of federal law to sell cigarettes to anyone under 18. And the regulations included other provisions that were meant to reduce youth smoking, such as you could no longer have vending machines that were available to underage people. You couldn't give away tobacco products unless it was in a bar or something like that where underage people weren't allowed. You no longer could be, tobacco companies could no longer sponsor sporting events. So you may remember the NASCAR championship used to be called the Winston Cup. It no longer is. So those were regulations that FDA passed, all meant to reduce youth smoking. But in the year 2000, the United States Supreme Court struck those down in Brown and Williamson versus FDA, ruling that Congress had not given the FDA the authority to regulate tobacco. And then in 2009, Congress passed the Tobacco Control Act, which added tobacco to the FDCA and put this in here. So the preservation clause is basically saying, okay, states were going to allow you to do things that go beyond what we were trying to do previously and that we're going to do again. And Ohio has done that. It's cited in our brief, I believe, around pages 28, 29. There are provisions in the Ohio Code that specifically deal with the sales and marketing of tobacco products to underage kids. And those are fine. So if Ohio wanted to adopt a minimum smoking age of 21, that would have been fine, still is fine, and things like that. So we believe that that's what the preservation clause was meant to establish, because if you read it the way the state reads it, it basically reads 337A out of the Food, Drug, and Cosmetic Act. The state could basically make any violation of the tobacco provisions a sales restriction. For instance, tobacco products, the FDCA requires tobacco products to be registered, the manufacturing facilities to be registered with the FDA. And if the product is manufactured at a facility that is not registered at FDA, the product is it's a misbranded tobacco product, I believe. It's adulterated or misbranded. The state could just pass that statute that says, well, if you don't have your FDA registration, you're a violation of the state statute. That's relying on the
Council, you're about 2 minutes left, let me interrupt you and ask you a question or two here. Your brief indicates that some other Ohio courts have ruled on this issue. Has their ruling been consistent with the trial court's ruling in this case?
The bottom line, yes. The cases were dismissed. I think maybe there were different reasons, and I apologize, I would have to go back and look at those, but both...
Same results, the reasoning may be different, we can look at that.
And I will tell you that one of those cases is scheduled for oral argument next week, I believe a week from today, and the other is scheduled for oral argument at the end of September.
And Judge Hensel's question, was this matter brought as a declaratory judgment action?
There is a request for a declaratory judgment in the relief section.
And was that addressed by the trial court in its decision?
Not that I recall, no.
And you have 1 minute left in your time, Counsel.
Give me 1 second to check my notes, Your Honor, and if there are no other questions, that's all I have. Thank you very much.
Seeing none, thank you. And you have your 2 minutes for rebuttal.
Can I have this minute too?
He's welcome to.
Thank you. I'm glad that we got to the preservation clause because I didn't get there before. And I would argue that the FDCA explicitly preserves state power to deal with the sales of these products. And, they tried to make this a labeling dispute, but it really isn't. It's more than that. There's different ways that they are being deceptive here. One is the label is deceptive at this point, and it's not required, we would argue, to be on the product because of that. It's clear that I'm not going to say ridiculous, it would be unusual that they would require deception on the product when it's an illegal vaping product. But also, if you look at this, it's also, they're putting it in a section in the store amongst all of the regulated products in which they conceivably know what's in it. They're presenting these as the same. Not only because of labeling, this isn't a labeling dispute, it's how they're selling it. And what they're doing is selling it deceptively by presenting it as something it is not, a regulated product. and they're presenting it as a regulated product when these 18-year-olds or whatever age person walks in there.
What does it say there that it's regulated?
Excuse me?
Where did it say on the product or the label that it's regulated?
Well, it says allowed.
Well, that's not regulated.
Okay, well, they're presenting it as
Go ahead.
allowed when it's not. Okay, I thank you for the correction, Your Honor, I appreciate it. It's presenting it as allowed when it is not. And this is a deceptive act. This label is only part of the problem. It's the sales of these, and what we have here is the appellee walking a line saying the FDCA said they want to be active, but they're not. Saying that we can't be active with regard to the deceptive sale of the product. Illegality and sale are two different things, and we are dealing with the sale, and I would ask the court to look at that case that I attached as supplemental authority.
And counsel, I'll know we're out of time, so you may briefly conclude, please.
Okay, thank you. Which is the Vapor Technology Association v. Whoop.
Well, briefly conclude, just let us know what you'd like us to do and not continue on your argument.
Okay, when you said that. Okay, I would ask that you reverse the trial court's decision to remand it so we can pursue our suit and protect the citizens of Ohio.
Thank you.
Thank you.
The court will take the matter under advisement, will issue a decision in due course. When that decision is reached, it will be mailed to you by our clerk of court and also be available on the Ohio Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentations this morning.
Thank you for your time, Your Honor. Thank you, Your Honor.
Okay.